Let's get started with this. Our story is Phil Mickelson and other golfers have filed an antitrust lawsuit against the PGA Tour in a report. Golfing and lawsuits, they go together. 3 players have filed for temporary restraining orders to compete in next week's FedEx Cup playoffs. Now, there was once a golfing case that went to the U.S. Supreme Court on an ADA claim about whether or not golfers should be allowed to use, or more to the point, whether or not the tours were required to allow them to use golf carts. And so there was a whole thing about that at the U.S. Supreme Court one time. So perhaps something similar here. The ongoing battle between the long-established PGA Tour and the Saudi-backed LIV Golf League has finally gone beyond words. 6 major championship Phil Mickelson has joined 11 other golfers in filing an antitrust lawsuit against the PGA Tour over the indefinite suspension of members that have defected to rival circuit over the past few months, the Wall Street Journal reported. So we've got a bit of interplay between different groups and different organizations that recognize golf differently. There are different companies, for lack of a better description, different sporting agencies, different leagues, I suppose, that recognize different sports in different forms. And we've got a bit of a problem here because, well, the PGA has said if you go play in their league, you can't play in our league. So that immediately, one of the things that immediately gets your attention is antitrust, maybe. The idea that they're creating an illegal restraint on trade, right? And you can't have illegal restraints on trade. So that would be the idea. In addition to the complaint, the 3 other golfers, who are Taylor Gooch, Hudson Swafford, and Matt Jones, have all filed for TROs to complete in next week's FedEx Cup playoffs, arguing that they are qualified before joining LIV Golf. It seems a bit unlikely that a court would order the league to force them to play. And apparently the DOJ has looked into this in their antitrust division to figure out whether or not this is all proper or not. So that's fun. The PGA commissioner has issued a memo informing members that anyone who competed in the LIV golf events would be ineligible to compete in tour-sponsored events and the President Cup. These players have made their choices for their own financially based reasons. Probably. They are professional golfers. One would think that they have made the decisions at least partially based on the financials, yes. But they can't demand the same PGA Tour benefits, consideration, opportunities, and platforms as you. Why not? That expectation disrespects you, our fans, and our partners. You made a different choice, which is abide by the tournament regulations you agreed to which you accomplished the dream of earning a PGA Tour card, and more importantly, to compete as part of the preeminent organization in the world of professional golf. Join our league or join their league, but don't join both. Does seem like it might be a restraint of trade. Okay. The tour issued another memo last month clarifying the release of eligibility points lists for the FedEx Cup that removed these players suspended by the tour, not those resigned their membership. In a June memo to the tour membership, the commissioner affirmed that players who are suspended for competing in unauthorized events will not negatively impact members' eligibility for tournaments or their status on the tour. Consistent with the statement, the policy board approved the creation of the FedEx Cup playoffs and eligibility point list, which does not include the suspended players. Perhaps improper retaliation of some kind. Yeah, this seems like this is raising some flags. According to the report, the lawsuit filed in the U.S. District Court for the Northern District of California argues that through these disciplinary measures, the PGA Tour is harming those players' careers. The tour's conduct serves no purpose other than to cause harm to the players and foreclose the entry of the first meaningful competitive threat the tour has faced in decades. An earlier report from the Wall Street Journal revealed last month the Justice Department has already launched its own internal investigation. Thus, that brings us to our end of our current discussion about Phil Mickelson and other tourers suing the PGA Tour because they signed up to play in the LIV Tour, and because of that, and apparently only because of that, the PGA Tour isn't allowing them to compete. So it seems like it might be an improper restraint of trade, right? Just because the players agreed to it, just because they agreed to the contract, well, The antitrust law says any contract, among other things, that is an improper restraint of trade is invalid. Now, exactly what that means gets very, very complicated very, very fast, because this has all been built on law since the Antitrust Act hasn't had a revision in over 100 years. But the idea here that there's an improper restraint of trade, even if you agree to it, is not wholly without merit. It might be without merit once you get into the factors, and there might be proper business reasons that they're doing this that are not antitrust reasons, in terms of it just being purely protectionist. Or maybe it is purely protectionist. Who knows? Well, I suppose one of the people that's going to have to figure that out is the federal court in which this lawsuit is sitting, at least for the moment. That brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.